day 3 of the Kouri Richins trial. Yesterday, we got to finally listen to the lead detective's testimony after a day and a half of waiting for the attorneys and the judge to figure out what type of evidence is going to be coming in. I have a sassy Corgi underneath me, so I don't know if my microphone is picking it up. It might not. Oh man. So yesterday we got to listen to some jailhouse calls. Oh, I think the court is finally back. All right, let me mute this. We got to listen to some jailhouse calls. We got to read the orange notebook diary entry, and we got to read a handwritten note from Kouri Richins. There were phone calls between her and her mom and her brother about the book, about the love note. Oh, no, sorry. The phone calls were about the love note that was put right next to the egg sandwich, apparently. But Kouri seems like she's denying it, and she's like laughing it off, calling everyone idiots. There were text messages between the mom and Kouri, and then Kouri and the brother about the book that she was writing. And it seems like she was planning on writing on maybe a second book. Then also we found out, which I don't know if it's really relevant or not, but it came in anyways. We found out that the children's book that she wrote was actually written by a ghostwriter, so she did not write it. And what else was there? I mean, that's pretty much the gist of it. I uploaded a video yesterday covering the... I had like clips of me watching and covering the orange notebook portion, some of the phone calls, and then the walk the dog letter. The jury got to listen to Jeff O'Driscoll read contents from the walk the dog letter, and it looks bad. Okay, the walk the dog letter looks really bad. If there are portions of yesterday's testimony that was confusing, I think the walk the dog letter was probably pretty clear. But then again, I have read it a million times. But I think sometimes there are portions of the state's, presentation that I'm not really quite sure the jury will be able to track with it. For people who are very familiar with the case, we know exactly where they're going with it, but I hope it's not too confusing for the jurors. Like, for example, when they showed the notes of Kouri Richins, where she was basically recapping what happened the night Eric died. Not in the diary, but the other handwritten notes that were seized about a year and a half later. I don't know if the jury knew what was going on with that. Maybe they were like, oh, what if Kouri is telling the truth? And these are her notes of what really happened. But anyways, alrighty. The jury is not even in yet. So what is happening here? They are really stalling today. What is going on? Oh boy, maybe I should have started a little bit later. But let's just jump in. Let's see what's going on in court today. Jury's not in yet. They are waiting on standby. So the state is presenting their last witness, Detective Jeff O'Driscoll. We're going to finish his cross-examination today. And then I'm sure the defense will put in a motion to just, dismiss the case like they always do. If it gets denied, then the defense will be able to put on their witnesses to testify on the stand. Alrighty. Boost up the audio.
We need to have regarding the text message excerpt that the defense offered during cross-examination of Detective O'Driscoll at the end of the day yesterday.
Yes. Oh, that's right. They went into sidebar yesterday. That's where we ended off with. We went into sidebar, I think something about text messages, and then they ended the day, I think about 15 minutes early. What was the text messages about? Something about jailhouse calls. Let's see. Text message. Oh, a text message between Kouri and Eric. So it seemed like the defense was wrapping up their cross-examination, because usually when we start getting like boom, 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 boom questions that recaps the defense's, points, then that's when I'm like, okay, we're coming to an end. So yesterday we ended with a bunch of text messages. It's like, oh, you didn't go through the text message between Kouri and Eric the day before he died. Isn't that important? And then Kouri was staring down, and she was mouthing to people and shaking her head. And then we went to sidebar. Okay, let me. I didn't know you were that stuff. I'm sorry. There you go. Got that. Good now. There you go. You're not stuck anymore. I'm sorry. I thought he was just being a drama queen. I didn't know he was like stuck. But if you're stuck, why are you going back in there? What a silly guy. Hey everyone, how are you doing today? Hi Jen, Taxi, Rain, how's it going? Michael, Richie, Kat. Guys, thank you so much for joining us. All right, text messages.
Yes, Your Honor, I think we do. May I stay seated so I can read my,
Of course.
okay, just 1 second, let me pull it up.
If we can all look at it at the same time, I'd appreciate it, Katie.
Are you looking at the celebrate one or the, okay. So it's up on the screen right now. So it starts with Bates number state, STATE, 0335281.
Good morning.
And this was produced to us before the state went through and updated the time. So this is on UTC time instead of mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, anyway, hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But
I bet. And I bet it's so confusing to keep track of it all. Good luck, Ms. Nestor.
this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrite extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrite and extracted by Ms.
It's kind of cute. People in Utah call it celebrate. Usually when we watch trials in other states, they just call it celebrate. But I like seeing the quirkiness of like different states and how they pronounce things differently.
Gibson.
Can you show me the Cellbrite?
Yes, sir. We can, and we're pulling it up right now.
Oh, well, the judge pronounces it celebrate. So I don't know. Maybe it's a defense team thing because Mr. Ramos also pronounces it celebrate.
Katie, the cover page, and then I'm working on the box download so she could download it.
Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right?
Typically, these are a complete string that has a Cellbrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Celebrite header. Only some of them, not
I
all
don't
of them.
know is that true? I thought
That's
all
true.
of them had the
No.
Cellbrite header.
No, that is not true.
Hold on, let's pause there for a second, because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, I mean, we've had CDR-related metadata regarding text messages. We've had some...
CDR stands for call data record, I think? Sorry, they're speaking like all these acronyms. I'm trying to remember which is what.
non-bubble related or non-bubble depicted
Correct.
cell messages that have come out of other extractions. But in terms of blue and green bubbles,
Or so bubbles, like you know how like iMessage, there's like blue bubbles, Android, and green bubbles. We speak it in bubbles and CDRs.
I thought all of them had a Cellbrite header.
Yeah, I believe that's right, Your Honor.
And
If we
celebrate.
prepared an exhibit that comes from a Celebrite extraction, it has the Celebrite header.
Right.
There's others where we just, we've got texts from other means. Somebody sent us forwarded this text, right?
Right.
If
Screenshots, for example.
correct.
Yeah.
If it comes from a Celebrite extraction, as best I recall, it has the Celebrite header.
Okay. Ms. Nestor, I'll give you the record back here in a second. But it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So
I think she wanted to admit, did she mention there was like conversation between Kouri and Eric about Mexico? Was that the text messages?
these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th, so it's from the 3rd.
Okay. These 3
But he could have died late evening on the 3rd. We don't.
bubbles are the sum total of their text traffic on the
No,
3rd?
we have more than 3. There's, just a minute, there's a couple pages to it. It's the last set of text that they, there's multiple, see, that's the 2nd page. And, yeah. And that's the last text that they had between the two of them before.
Can you go to that one, please? Katie, can you blow up the 3rd one on that sheet?
Katie, can you blow it up so I can see it too? Thanks, Katie. Good morning.
So,
Hi,
as I
Kurt.
understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yeah, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the time sorry, the daytime information is inaccurate.
Well-
Correct?
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected, and I would expect during, for the Celebrate downloads that we have authenticated and laid foundation for, the time change is baked in,
Consistent across the board.
consistent across the board.
Right.
So the fact that this is still in UTC -5 instead of UTC -6 or 7 just caused me to question where this came from, which Celebrate download it came from, and I still don't know.
So that brings us to, is there a version of this that has the Cellbrite header?
That's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No
It's
problem.
very long, so we have to go right to it. Just give us just 1 minute.
No problem.
I mean, I think he could have also passed on the 3rd, late evening,
Oh, you want a Mac? Oh, God.
technically, but he was pronounced dead on the 4th.
Our millennial has a Mac, so it may take a second.
Well, this discussion doesn't need to be had with me on the record in front of everybody. If you can have it with each other first and then distill down what the dispute is, if any, regarding foundation.
Yeah.
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we can work parallel while they're
Yeah, wouldn't it have been better for them to confer with each other after trial ended yesterday, so they can figure out where they came from, what time zone, all that stuff? Why why are we doing it right here?
seeking out the foundation information. We could address well, a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's further objection is that it's beyond the scope of the direct.
Let's handle those one.
Oh, that's true. I don't think these messages were brought up in direct examination.
Okay.
Ms. Nestor,
So Blood was saying that it's beyond the scope.
regarding hearsay, your client's statements are hearsay if they're offered by you.
Right.
Eric Richins' statements are categorically hearsay if they're offered for the truth.
Right.
What is the non-hearsay purpose of these particular text messages?
So we are actually not interested at all in what is being said, and we could do an instruction to that, excuse me, to that effect. What we were trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd, and that was sent the day before. That is connected to the GIFs, whatever you say, that all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called witnesses about it.
Provide a little more context. What
Oh, Miss Nestor. I mean, I made such a big deal out of those gifts too. My gosh. I mean, I'm gonna have to change my wiring, just say gifts. I made a huge deal out of them too because they look really, really bad. But, if the defense is trying to downplay those gifts and be like, oh my God, the state made such a big deal about it throughout the trial. They even said in their opening statement, then you better have something good to back up what you're saying. That they really are not a big deal. And there's an explanation as to why those gifts were accessed after everyone left the morning Eric died. Man, I'm just saying that, throughout this trial, the defense will build up to something and then it'll just be like, the payout just wasn't there. And that kept happening many times. It's really annoying. So there better be a good payout to this. Because if there is a good explanation for those gifts, I think that could be a good start for the defense.
is the photograph of, and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever.
Okay.
And he sends her a picture of it while he's there, before he gets home that night. That is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning at 8:40 as soon as the police leave. And they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was, the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're trying to explain to the
At first, I thought the route that she was taking was that, well, Eric was the one who accessed it. Eric was the one who sent it to Kouri. And I was like, because Eric was celebrating buying the Midway mansion and he thought it was going to be rich, but that's not where she was going. She's saying that those 3 gifts, apparently, it seems like they all had the same timestamp as the gravel spreading photo. And she's trying to show that those gifts was not they were not necessarily accessed when the state thinks it was accessed at, which was the morning after Eric died when everyone left. But I mean, we're talking about, you know, like when you're on your iPhone and you hit, I think, the plus button and then you like search GIFs on there to send people versus accessing a photo that's on your iPhone. I think that's like completely different. They're like completely different, like in completely different areas, but I'll wait.
The jury. All I care about is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs at the exact same time, and it was sent the day before. And that's all we're trying to do. We don't care about what's in the bubbles. We can black out what's in the bubbles. I don't care.
Why are you doing this through Detective O'Driscoll? Why didn't you do it through Mr. Kotradimos? I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he
Oh, true. Because Mr. Contrademos, the digital forensics guy, he was the one who was testifying about the gifts. Did they just think about this? That's why they're trying to squeeze it in through O'Driscoll, and they're like, fuck, well, Contrademos already testified, and then we already lost our chance. That's a very good question, Judge. Why are we asking Mr. Jeff O'Driscoll? Is it because you think that he's going to be like, I don't know. I have no fucking idea. We hired an expert. Go ask the expert. Because that's what he was kind of doing yesterday. He's like, listen, I'm the lead detective, but lead detective doesn't actually mean what you think it means. It just means that I kind of just oversee people, but everyone has their own designated duties that they do, and they're more specialized in it.
He testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see he sent her a picture the day before? The rest of it we'll do separately.
That's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why defendant believes it's relevant. I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any of the metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri? That's all I'm asking. Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture.
Something tells me they forgot or they just thought of this and it's too late to do with Contrademos. I guess, like, couldn't they have technically... No, because it's... I was, like, thinking, like, could they just call Contrademos on their side? But no, they already have their own expert. Yeah, something tells me they forgot or they just didn't do it and they just thought of it now. And they're like, well, shit, Contrademos already testified, so how do we get it in a different way? I don't know. Or maybe they legitimately thought the strategy was better to ask O'Driscoll this, because O'Driscoll would say that he doesn't know the technicalities of it. But if it was Contrademos would probably be able to provide context with his expertise to rebut the defense's claim that it was, you know, like, oh, it's not the same thing because blah, 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 blah. So maybe they wanted to ask this through a witness that wouldn't really know the technicalities of it. Although I will say this, I mean, it's not like the state will probably be able to call Contrademos anyways to rebut after the defense's expert, but maybe that was the strategy. I don't know. There's like 3 different things that I think could have been happening. Forgot, just thought of this, or thought O'Driscoll wouldn't push back because he is not the technical expert.
Picture. That's
Well,
all I
without the
care
metadata,
about.
the picture is not relevant.
Well,
You
the
need the date and time.
We have that. No. We do need the date and time, but I'm talking about the... I thought there was more information on the bottom of those things. And
Why
can
are
take
we
that.
doing this through Detective O'Driscoll rather than through another witness that can testify regarding the relationship between the file path for the GIFs and the file path for this photograph?
Because O'Driscoll wouldn't know what the fuck it is. He'll just be like, I don't know. And then the defense will be able to make their point and then maybe move on. I don't know.
Because he reviewed it and saw it. I mean, I think he can testify to it.
You can't testify to any of the technical relationship that you're asking for.
Correct, and we're not asking for that. That's all we're asking him is to say that the picture was sent the 3rd. That's all I need him to say, and he knows that because he reviewed it, so he's capable.
He knows what he saw. How does he
Right.
know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so
But that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it? I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that this witness has foundation to give you the testimony you're asking for. What's the question you're going to ask?
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said yes.
Okay. And then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm not asking him for
I'm not sure
any
that's even
technical.
in dispute. Go ahead, Mr. Glover.
Let's never come out before on any other witness.
Okay. But go ahead, Mr. Glover.
I didn't have anything, Your Honor.
Okay. Is there any objection to him just saying yes or no to that question?
If the, yes or no to the question of, did he review Eric Richins' text messages from the...
I think that's already been answered. Yes
Okay,
or no.
yes. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
Was Bloodworth just tooting this out? Mr. Bloodworth, are you okay?
And so if...
And if Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that...
I just want to let you guys know the jury is not even in yet. Okay, I'm looking at the live feed. They're just still yapping.
is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph, Ms. Nestor?
I do want to publish the photograph.
And tell me why the photograph is relevant?
Well, that photograph is already in as part of Exhibit 340, which
in?
It's not in, but we've stipulated.
we've stipulated is coming in next. But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in
We've stipulated to it. It's about to come in.
through.
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What,
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see on. I still think there's a hearsay problem based on counsel's explanation. Now, I also think there's a relevancy objection. The photo that we've been discussing,
The gravel photo.
the gravel photo, was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the premise of the question, Ms. Nestor,
Yeah, like, isn't it possible that Eric sent the photo to Kouri and then Kouri accessed it the next morning? Could that have just been an explanation? Because the photo of Eric, the photo is different than like accessing GIFs.
we're seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publication is a hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
I'm not sure that follows without additional context. Just sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just a photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the defense has, the defense has, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping phone.
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died, yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd, yes or no? Yes. Is this the photograph that he sent? Full stop.
Oh, I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh, no, fair enough. I'm not telling you how to testify. I don't know what it'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand, do we have a common understanding of the limits of what you can ask Detective
Absolutely.
O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't. It's too hard for him to. I mean, I think it needs
You
to
can't
be.
show the text messages without provoking the hearsay problem.
No, not to the jury, just to refresh.
Oh,
Because
that's
I think it's got to be. He's not going to know. It's just going to be a weird picture.
understood.
Should we just go
Are
ahead
you going
and?
to publish the photo to the jury, though?
No.
Oh,
Excuse
okay.
me.
So
Sorry.
we could just go ahead and admit 340 now, because then the next question is going to be: is this the same photo that is in this picture right here? And then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now there's the follow-on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
So
it.
is
I'll
somebody
do
going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
Good morning. Thank you. I didn't have time to mute my microphone. I was perplexed by Amazon's email. They're so sneaky. I return items and then they're like, oh, it seems like you return extra items in here. Thank you so much. We understand that sometimes you guys get extra items and it's not eligible for return, but we'll keep it anyways. I'm like, no, I did not send you guys any extra items. These are all items that I want a refund for. What the heck?
That's fine. We do have one other, if we're resolved with this. I think we're all clear. I know what I can ask, what I can't. I think we're fine.
Okay,
There's another issue. May I bring it up?
please.
All right.
This is crazy. I did not know they were arguing about this one issue for this long. Mad Mongilo? Hi, Matt. How are you doing today? I have no idea how to pronounce the second part, but feel free to let me know. Hi, Matt. Thank you so much for joining the membership. I appreciate it. Hello. Welcome. Enjoy your quirky emotes.
I really need Officer Driscoll to leave the court when we talk about this because it's about specific questions.
No problem. Detective, if you take a step into the lobby, please don't talk to anybody while you're out there, sir. Thank you.
So I feel like there's like a million different ways that I could pronounce that. Mad Mongolo? Or maybe the double L's are like a Y sound.
Thank you, Your Honor. I'm doing this out of an abundance of caution to avoid
Okay.
any potential. I'm trying to be very careful to comply with the court's ruling on the motion in limine not the motion in limine, the motion to admit the statements of David Norris.
David Norris?
so-
Not.
Correct.
Yeah.
Our motion to admit that was denied.
Yes.
So just to make the record, the defense sought in advance to get approval to
Was this sealed? I don't remember seeing this in any of the pretrial stuff. And then we went over like the most recent motion in limine. David Norris. Does anyone know who David Norris is? That does not ring a bell. Ah, that's what I get for American Italian. Wait a second. Do they cook though? Mongilo. You know what? We went to Italy for the first time last year. I freaking love it. It's the best. The culture, the people, the food, delicious, fresh ingredients, and the prices amazing. And I love how when you go into restaurants, we were in Florence, right? Or like some other restaurants. Well, Rome is okay, but I really like Florence. They treat you like family. Oh my God, it was so cool. It's such a different experience than going to Japan, right? Japan's like very different. It's like eat, be efficient, get the fuck out. But they're very nice and warming though. But in Italy, it's like, I don't know. It's like they are like just like, it's like an emotional comfort, you know, like you're getting like hugs from them. I love Italy. I want to go back so bad. I want to go to northern Italy. And Salone.
actually, we gave notice to the state that we intended to call a witness named Mr. Norris,
Mongilo.
who would testify if called, that on an occasion in 2019, I believe, in 2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl. He had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Or for Kouri, but
Correct. The court did, the reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
the residual.
The residual, I'm sorry, I call it catch-all, same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand to testify because the residual hearsay exception requirements were not met. It is my desire with this witness to ask him the following 4 questions about his investigation. And it touches on Mr. Norris's testimony, but it's a separate matter. But I just, out of abundance of caution, I am giving you a heads up. So the first question is this. You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got it right.
I'm sorry, I do have these if you want me to email them to you.
No, it's okay. Just
Okay.
give me a moment.
No worries.
Was it prior allegations that Eric?
Any allegation that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Got it.
And this is the next question. Within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl. Want me to read that again?
Sure.
And within the past few months, did your team of investigators become aware that there was an individual?
Oh, was I muted? Sorry about that. Allergy season. I was saying that I knew something was up with the courtroom. I was reading Yoke's message. Kouri, you're gonna love this judge on this. I stopped watching after you came online, but shit, the defense made a huge error. The jury was supposed to come back. I saw that they continued talking after the break, and then now they're on a break again. So I'm like, okay, something's happening here. Something is up. It's only been an hour and a half, and we've already had like what, 3 breaks right now? Oh gosh.
Contacting the Summit County
No wonder this is a 5-week trial. You know what? Is it going to be a 6-week trial?
Sheriff's Department, who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl.
Take allergy
And there's one more
medication.
question. Let me know when you're ready, Your Honor.
Sheriff investigative team. Give me the last clause one more time.
Who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl.
Okay.
And the final question is, did you or anyone else connected to the investigative team ever sit down with this individual and talk to them? Did you make any efforts to see if this individual was credible or had corroborating evidence to back up their claims? And that's it.
Mr. Blood.
No objection to the first question. Objections to the next 3. This is a transparent attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible. This setup has been long in the making. After the court issued its 807 ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him.
Oh, they did interview him. Okay.
And he said he was calling on behalf of, or he was calling because defense counsel told him he should call.
Maybe.
Wait a second. You see Miss Nestor? Nestor was like, you said what now? Hold on a second. Oh, the state was like, they were plotting this entire time. Deputies, they did interview him. And defense counsel told the guy to come and talk to them, which I don't think is necessarily a bad thing, because it's possible that he tried to talk to the defense and then defense was like, okay, cool, go talk to the Summit County Sheriff's Office and give them your side of the story. But let's look at Miss let's look at Miss Nestor again. Let's see, Miss Nestor. Miss Nestor, I'm trying to zoom in on you. Right, that's Mr. Bloodworth. Let's do this one. Let's see if I can do that zoom in. Nestor, I'm coming for you, Miss Nestor. Oh, this one. Oh, I can't even see Miss Nestor. Miss Nestor, where are you? Oh, there she is. Miss Nestor. Miss Nestor she looked really offended. So let's see what happened here. Zoom, 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 enhance. Should I keep Miss Lewis? I'll keep Miss Lewis. There you go.
Or he was calling because defense counsel told him he should call.
Maybe just pause here for a moment. I don't know that we need
Oh, I think Miss Nestor was like, do we do that? And Miss Lewis is like, no, we didn't.
to go into any of that. I understand part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I think that's the beginning and the end of the discussion. There's no foundation for the premise of your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
Oh, you could make up any set of facts and just put it in the question. I'm gonna listen to that again.
The premise of your question. It's as if you...
Of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
I'm sorry, but I don't understand what you mean by there is validation from the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. there is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded, is someone contacting you, asking to give you information about it, and you refuse to interview them?
That's not the question you asked. Read the whole question.
Dude, he just said, read your own question. The question that you wrote out.
In order to properly investigate,
No, go to number 2.
that is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation, that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask you this way. What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
That's a fair question.
It would be reversible error for me to allow that question. There were 2 residual exception rulings in this case. Let's be fair about it.
Right. That's absolutely correct. So is there a way, if we scrub out the reference to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is
I think one of the best judges are the ones that can think of examples on the spot. I'm horrible with that.
why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them with information about an interaction with Eric involving drugs, illicit street drugs, and they chose not to investigate it at all, it does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all of their possibilities because they...
Wait, but the state did say that the deputies did interview him. Maybe they interviewed him and found that he wasn't credible. I'm just so confused. Why are we just skipping over that?
chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed, and they are like, no, thank you. I think I'm entitled to get that in, and I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible, but I do believe that's fair game. And I'm open to suggestions. Whatever I need to do.
These 4 questions are not it, Mr. Bloodworth. You look like you're about to say something. I'm sorry.
No, Your Honor, as I understand, the status quo is the court's, I guess this court has sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectional questions that are maybe more general, less specific, some version of probing the bounds of the state's investigation
Is that why they take another break so Ms. Nestor can recraft the question?
of the charges. Yep.
Your Honor, no. It's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may that there may be admissible evidence.
May I respond?
Yeah, hear me out for a second.
Sure.
Or let me make sure I understand the balance of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record so far, and the evidentiary record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence that's already
I
admitted
think it's this knee surgery,
is
right?
I just bumped up the audio again. I think the judge was a little bit low.
a 2016 hydrocodone prescription following knee surgery.
Right, okay. Very good. Now, by the same token, I believe all the admissible evidence of Ms. Richins seeking or receiving narcotics of any kind is already in, correct? In all is putting it strongly, but
Yeah.
That is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
Or it would come in a rebuttal case.
Understood. Okay. Which was the basis, among other things, of, not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. Right. So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you were accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis based on the law of the hoops you have to jump through to come under the residual exception. And for purposes of your analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true. And then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not. So I don't...
Maybe what he meant by Mr. Norris's, I guess, like, testimony has been so thoroughly dispatched. Maybe what they meant was, like, the deputies looked into what he had to say and tried to corroborate it and could not corroborate any of it. Maybe that's what he meant. Not at the court level, but, like, at the investigation level with the deputies. That's how I understood it as.
I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
The difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office, or Sheriff's Office? My apologies.
Yeah.
He says yes. And then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely.
If you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on. Fine, but I'm not sure how that's relevant.
Well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
But it's not being offered for the truth.
It's
being
100%
offered,
being offered
Your
for the
Honor,
truth.
if I may please, it's being offered for the same reason they've gotten in a ton of other hearsay in this case, by the impact it has on how they did their investigation. They got that in through Woody. That's how they got in the Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out. This is the same exact argument. It's how the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor, then
Yes.
the 807 residual exception wouldn't exist, and it wouldn't apply. It does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why the substance of what he told the Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy substance and just say there was an avenue that you chose not to investigate. But I've got to get something in context so the jury understands, hey, you have this road, you chose not to go down it. That was your choice.
I appreciate why you want to present this to the jury, but there are limits
Right.
on both sides of the V about what gets presented to the jury. And those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence. For the same reason that the state could not argue that we want to get in Hayden Jeff's statements to his sister just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario.
So the reason why Hayden Jeffs keeps being brought up is because the state was unable to get more testimony from what happened around Hayden Jeffs, because well, one, Hayden Jeffs, he did die, unfortunately. And the thing with Hayden Jeffs in pretrial stuff that we found out was apparently Kouri had reached out to Hayden Jeffs before anyone else, like before Carmen and before going to Rob Crozier. And Hayden Jeffs is like one of the handyman. And so she goes to him and she asks for, I forgot what it said in the pretrial docs, but it was like either fentanyl or like pain pills or something like that. And I think she tried asking for it twice, maybe. And then at some point they just stopped talking to her. That's what I remember. We have it somewhere around here. But of course, you know, that none of that was really allowed to be let in. Although his significant other, when she was testifying in the stand, she did accidentally say it out loud. And then, you know, the judge was like, oh, guys, you have to unhear that. But I'm like, oh, I don't know, man. The effect is already there. They already heard like the fentanyl portion. So if you guys are confused about who Hayden Jeffs is and why they keep bringing it up, that's Hayden Jeffs.
Yeah, which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen.
Oops, sorry, monster just came in here.
Which we're going to be allowed to question him.
Sister, just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it, would we be having this conversation?
That's not this circumstance, though.
It is the same, though, because that evidence has nothing to do. Here it's even worse because it's inadmissible.
It's inadmissible from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance isn't admissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant, but without the substance, it's not relevant.
Yeah, I mean, I get what she was trying to say earlier. She's basically trying to say that, hey, you know, there was someone who had information and you guys didn't properly investigate it, because she's trying to poke holes at the investigation. But it comes really complicated because the judge already ruled about this Norris's guy's testimony and said that it's inadmissible. Oh yeah, drink some water. I mean, you can just leave it there. He'll drink it.
Yeah, just a moment.
Sure.
And I'll, of course, respect it. Okay, you're
Like, I get what she's trying to say, but also I can see why the judge would think she's trying to circumvent his ruling, because initially when she proposed the 4 questions, some of it was kind of specific. So, for example, question number 2 was like, you know, to investigate the accidental overdose, did you look into the prior allegation, even though she said allegation, but it's still being thrown in there, that Eric had prior history seeking fentanyl? Jury hears that, it's like, oh, wait, okay, that's kind of weird. That's interesting. Why didn't we hear about that, right? And then also, in the past few months, are you aware of an individual contacting Summit County about an incident about Eric asking for fentanyl? So it's like, you knew where you were going with those questions. You knew what you were doing. Like, yes, you know, you're like, well, what do you mean? I'm just trying to poke holes in the investigator's investigation. I'm not trying to introduce this testimony that wasn't allowed in. Like, Ms. Nestor, sneaky, sneaky. I mean, you gotta try. You gotta try.
I think we've made our record on that, and I'll, of course, respect the court's ruling on that.
I mean, you have no choice. Also, to report back from the live trial, they are still, this is live, right? What is going on here? They are still on break. We'll catch up. Why did they have such a long break? What is happening? So one of the comments wrote, 2 hours in and nothing. Oh, I wouldn't agree. There is stuff happening right now, but yeah, no testimony.
let me take a minute.
Yeah. And then so she was like, well, what if I ask broader questions? And it seems like even that's not going to be coming in. But maybe she could make it so broad, like, oh, did you do everything to investigate other potential theories? I guess she could say something like that. But she can't bring up this other individual that contacted the Summit County about this incident of Eric asking for fentanyl. But okay, judge is going to think about it.
Let me just take 5 minutes.
Thank you, Your Honor.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before we invite the jury?
No, thank you, Your Honor.
Mr. Blood.
I feel like Mr. Bloodworth is pretty quiet today. Mr. Bloodworth, you good over there?
No, sir.
Okay, I'll be right back. Thank you.
All right, Judge, we'll be right back. We are going to forge through. It's just let you guys know, it's not a 5-minute break. Oh, God, it's like a 20-minute break or something. All right, Judge is back. See what happens.
Counsel, thank you for your patience.
Okay.
I've just handed you a copy of State versus McCullough, 2014 UTF 215. I need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do.
Okay, actually, kind of want to read it. What is it called again?
14 UTF. I've just handed you a copy of State versus McCullough, 2014 UTF 215. I need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation.
Oh, okay.
By also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeff's statements to his sister. Pause for a second.
Wait, what? Wait. Oh, so they okay. Hold on, I need to process this.
Charge of an incomplete or this case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeff's statements to his sister. Pause for a second. I need you all to be very thoughtful about this. I can't.
Wait, to his sister? You mean his significant other? Or is sister a different phone call?
Unring the bell once this information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Wait, so okay, now I want to know more about Hayden Jeff's reaction with the sister. I'm assuming he didn't misspoke and actually mean sister. So maybe there's more to this. Maybe this Norris guy, maybe they have some sort of ties to Hayden Jeffs and the sister. Because when I was thinking about comparing Norris and Hayden Jeff, I was just thinking like, oh, it couldn't come in because of the judge's ruling from before. So like for Hayden Jeffs, it's like all hearsay, right? For Norris, I don't know. I didn't see the ruling for that one. I didn't even hear about this Norris guy, so I wonder if it was sealed. Maybe it wasn't sealed. But now I'm like, wait a second. I think there's more between Hayden Jeffs and this Norris guy that we don't know about.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, It would also cause us to revisit the court's decision yesterday regarding Mr. Bonsavage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive
The
me.
Xbox.
Oh, I think I do.
The
Yeah, a
Xbox
little
controller.
bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement in a question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do? This information, this statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. And I'm not sure Detective O'Driscoll's that guy. By the same token, to the extent the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or...
Oh, okay. So they are connected. Ah. Okay. That's why he kept bringing up Hayden.
Then the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or information received or is told by Mr. Bonsavage. They're going to have to call a witness that had personal knowledge of those statements and then lay foundation for what occurred next. We can't skip steps.
Okay, now I'm curious though. Why do we not allow the statements in from Norris in the first place? If we're doing all this, don't we just have to let Norris's statements come in? I'm going to go through the court docket again to see if I can find their ruling on Mr. Norris. I just don't remember this at all. But again, there was a lot of sealed stuff on there. So maybe that's what it is. Give me a second. I'll load it up. Oh, wrong one.
Your Honor, agreed. There's a little more to unpack here, too. Because I happen to know that Jeff O'Driscoll's not the witness for this. We would need time to prepare the witness for this. We also have the problem that...
All right, guys, let's add another 2 weeks to this trial. 7 weeks trial, let's go.
We meaning
The state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point, imagine it's not Jeff O'Driscoll, as
Right.
you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris. Or they call David Norris.
Sure.
And they ask, did you
Sure.
call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to...
Oh, fun fact. Kouri's birthday is on 4/20. I don't think I ever noticed that. Well, maybe the gummies are hers.
information regarding the Hayden Jeff statements and the Nick Bonsavage statements. That would come in the state's rebuttal case. Is that correct?
Not necessarily, Your Honor. I mean, we haven't rested. I think
Fair.
we would like to get out in front of this
Okay.
before a rebuttal case. And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about. And the state would want to continue that investigation.
I think I know what you're talking about, but in terms of how it came to be that David Norris contacted law enforcement when he did,
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you.
Yeah.
I don't think so. My only point in mentioning that is it would just take a little.
Yeah, it's fucking. It's classified. Sorry, it's filed as private, so I can't even see it. That's why I have no idea what they're talking about this Norris guy. I don't know why this Norris guy's. Yeah, I don't know why his testimony was excluded. It's all filed in the private. Maybe the assumption just hearsay, like Norris heard from someone else that Eric was trying to get the fentanyl, and that's it.
Little bit of time, and it would be necessary.
Am I wrong to say maybe this should have been handled prior to trial? It was. They excluded his testimony.
The other point, I think, well, the other objection.
But Miss Nestor was trying to be creative. She knows that the testimony of this Norris guy is excluded, but she was like, well, I kind of want to bring up the Norris guy, but not for the purpose of, allowing his statements in. I want to show that the investigators didn't do their job properly and thoroughly because they didn't investigate all avenues of how Eric could have died. And in this case, it would have been by accidental overdose, right? But the questions that Nestor was asking was very specific because she was trying to get in Eric asking someone for fentanyl.
The state has is under 403. I think in proceeding in this manner is both prejudicial and confusing the jury.
If I let in everything, though, so Norris, Jeffs, Bond Savage, does that ameliorate any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope of law enforcement's investigation, not for the truth.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both that assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think because of the complete incredibility of David Norris's testimony and how David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than confusion related to recorded interviews with Hayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't. David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect. Just because the information provided to David Norris is highly in doubt and would be highly litigated, whereas the information Hayden Jeffs provided is recorded. There is zero doubt about what he provided. And the information that Nick Bonsavage provided is recorded. There is zero doubt. We're not bogging down into some mess of who said what when.
When you say the information, you mean the substance of what David Norris told Summit County Sheriff's Office a number of weeks ago?
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Forgive me. What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once He spoke with a patrol deputy to take kind of the initial.
Who's this David Norris guy though? So I guess what the state is saying is that this David Norris guy like has not been consistent in what he said. We've got one affidavit, we got another affidavit. There's a phone call that he made. There's an interview that we did of him, and what he is saying changes depending on when he speaks to defense counsel. Ah, man. This is starting to sound like maybe a waste of time.
Well, I guess there's one to call into dispatch, which was non-substantive.
Okay.
Then there was an initial contact with the patrol deputy, and then there was a contact with the detective.
Okay.
And then we have the affidavits that he'd submitted, the defense has submitted in the 807 litigation.
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Just to clarify, they weren't affidavits. We just laid out a statement of facts in our motion.
Okay.
It's a proffer.
I'm familiar with what you're referring to. I'm a little less clear on
Sorry,
that. Yeah.
proffer is,
Yeah.
proffer is the,
I'm not sure the proffer has any impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
none of the proffers do tie into this in that, the question would be, did this inform your investigation? Yes, we considered all of his statements to include the defense proffers in determining that they were just flat out incredible.
Okay.
So that goes to kind of the confusion argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is the same as the weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
And to put a finer point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need
It's jury confusion,
Right. And
yes.
so what is it you believe they would be confused about?
I think they would be confused about the effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of Norris, whereas those waters are crystal clear in the case of Hayden Jeffs and Nick Bond-Savage. And the waters are muddied as it relates to Mr. Norris very deliberately. And I don't know, I suspect the purpose is to confuse the jury, right?
As you sit here today, have you identified the witness that would testify regarding investigators' knowledge of and response to statements made by David Norris?
I know, I don't remember the name. I know the patrol officer, I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right? And so...
You would be able to call an investigator, not a lawyer, right?
Right.
Yeah.
So probably 3 witnesses.
Okay. And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Hayden Jeff's statements to his sister? Or, I appreciate that Hayden Jeff spoke directly to law enforcement in a recorded interview.
Right, that's what we would have to get into. What did you understand, why, with what level of detail, which is extraordinary.
And there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, Judge, there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nick Bond-Savage jail call, right? That entire jail call comes in lock, stock, and barrel. If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice? I think the court, in considering the weight of the various prejudices, the prejudice with admitting Norton versus versus the prejudice of the Hayden Jeffs and Bond-Savage, I think the court needs to, in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence and the fact that David Norris's assertion is not at all probative because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case, whereas the Bond-Savage statement and the Hayden Jeff statement is highly corroborated with all was a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation and probative value to the state's response to that theory.
Correct, under the 403
Got it.
balancing.
I understand your position.
Okay.
Ms. Lewis, Ms. Nestor, Mr. Ramos, this is high-stakes poker.
Yes, it is. I was just going to ask you if we could have a little time to meet with our client next door. She's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the substance of David Norris's statements should come in not for their truth, but for their effect upon law enforcement and investigators, for their probative value to the defendant's theory of incomplete or incompetent investigation, that by extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Hayden Jeffs and Mr. Bonsavage, not for their truth, but to show what they were doing and how they were doing.
Can I just get a clarification on the Bonsavage? I want to make sure I'm on the same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Yes, Your Honor. In a March 4th, 2022 jail call between Mr. Bonsavage and an inmate in Gunnison, they're discussing purchasing a PlayStation controller, and they're discussing who's going to pay for it, kind of how to get the money for it. And Nick Bonsavage says to the inmate something like, Carmen will cover it. She just made money selling fentanyl.
So this is already another than we
The word
substituted the word fentanyl
We
for
illicit street drugs. Right. And that's a recording,
It is a recording.
as is Hayden Jeffs' interview with law enforcement.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I explained to her, in really colorful language, how dangerous it is. She wants to stay away from it. Who on earth would want fentanyl? And then there's a second phone call where she calls back and asks for the Michael Jackson stuff, and they get into a propofol discussion.
Right. Okay. How much time do you want, Ms. Nestor?
We have 30 minutes.
That's fine.
Thank you, Your Honor.
Anything else before we take a recess, Mr. Glover?
No, Your Honor.
Ms. Nestor?
No, sir.
We'll be in recess until 10:30. All rise. How does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll,
Oh, sorry, I didn't say anything important. I was just like, okay, let's go.
he's outstalling. He is not the foundation witness because he is
Thank you. O'Driscoll's not the foundation witness. Thank you. That's what the judge was saying all along.
Driscoll. He's outstalling. He is not the foundation witness because he is not the individual who communicated with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask the questions that he doesn't have, because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that. So we're going to wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
Okay.
And if we decide to go forward with that evidence.
I appreciate that. If you make that ultimate decision,
We'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense an opportunity to state on the record or at least summarize on the record, their strategic balancing of the risks and benefits so that there is a record of that going forward.
I appreciate that, and I think that's probably a good idea for everyone,
Okay, very
including
good.
us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay.
So my understanding was we went through all that, and now the defense is like, you know what? Never mind. Yeah, I don't think we're going to proceed that way. Yeah, I don't think we're going to ask that. Yeah, you're right. You know, O'Driscoll, not the foundation witness because he didn't communicate with Norris. Great. All right. Well, I'm glad that we got to explore that itch of yours, defense. Let's move on.
Okay. So, as a matter of status quo, we are going to proceed with additional cross-examination of Detective O'Driscoll, correct?
Yes, sir.
Did we reach an... Oh, I'm sorry.
Could we just go ahead and, well, I can just do it through, I think we decided I would just ask him about 340. I'm sorry, nothing, I apologize. I
Okay.
withdraw.
I was about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan is to introduce the stipulated 340, which we'll get in, and then I will ask him if he can identify the photo. If he can't, he can't, but I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce the bubbles or any of that.
Okay.
The only thing I'm going to display to the jury will be the picture on 340, and then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
Only the date.
Eric and Kouri on the date, it's a yes or no question?
Correct, just
Okay.
on the date, not the time, because I don't want to confuse anyone or require the UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth, anything further on that?
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
Ms. Nestor.
We are, Your Honor.
Zach, please.
Okay, so the jury's coming in. Yay. Please have a seat as you come in. All right, have a seat. Thank you. Is this the first time the jury's coming in for the day? Yes. 2 hours later.
Ladies and gentlemen, thank you for your patience. We will now proceed with additional cross-examination of Detective O'Driscoll by the defense. Detective, let's have you come in the courtroom. Detective, please step in front of Brittany. We'll get you sworn back in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Let's see if Miss Nestor changes her mind in mid cross-examination. Maybe she will ask it. Maybe she will bring it up.
Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth?
No objections.
State's exhibit 3-40 is admitted.
All right. And this was talked about when, I believe it was Mr. Kostradimos, I think, it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top. Okay. So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's
Frank Underwood.
Mr. Spacey and in a TV program, right? And those are the three GIFs that were talked about. And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m.
Whoa, I love that we are displaying this again. I will take a screenshot of this. Why, thank you.
On March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
All right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Kostradimos, yes.
Okay. Can you pull up another one of the photos that is the picture from the house?
It's because someone was deleting things.
That's it. All right. This is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there
I don't know if this means anything, though, because I think it's possible that she could have accessed this photo around the same time also. Just because Eric sent it the day before doesn't mean she didn't access it both times, right? Couldn't that just been an explanation? What if she was messaging someone and it was like, okay, well, Eric died. I have the money. And here's a photo of the Midway Mansion. We are going to sell it and make even more money. Like, I could see that happening too, with the same context of her setting these GIFs, like, I'm really rich and all that shit. I don't know if it really proves anything, but I'll let her continue to see if there's any other points that she makes. But it's possible it could have just been accessed twice.
there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit? Thank you. All right. And is that also just a closer up view of the Legacy Mansion?
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to the same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better? All right. Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure. And it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think that requires additional foundation.
I think the question pending is, are these among the things he reviewed, correct?
Maybe I misunderstood the pending.
Yeah.
That's the question.
So I think,
If we back up a step, maybe I'll catch up.
sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone
Yes.
on the day before he died?
Yes.
I don't remember all of them. I remember some of them.
So then would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth?
No, sir.
Okay. The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more and maybe blow that up a little, that photo? Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes, Your
So,
Honor, sorry, objection foundation is the meaning of died, right? He was pronounced dead on.
But I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection, his recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I've just got one more question about the photo, and then I'm done.
I'll take it down and ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you're about to
Yes,
ask next.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo is still up on my screen, and the witness is
I apologize. There you go.
staring at it.
Sorry. Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. I'm done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
Okay. I just want to see the photo again really quick. She didn't show it again, right? Okay. Did she delete this too? That's what I want to know. Do you think she deleted these? I wonder if she did.
Your Honor,
I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
Accessed at that. One more step. If we could go back to 340, which has been admitted, and pull up some additional gifts that were accessed at that same time. If we could pull those up, please.
Sure.
The argument that she was making was that Eric sent the Midway photo the day before, but yet it's showing that Kouri accessed it around the same time that she accessed those GIFs. But the Midway photo was not accessed at 8 a.m. It was accessed at 10 a.m. And then the explanation for that could just been she accessed it again. She accessed it when Eric sent it to her and she probably looked at it. And then maybe she accessed it when she was just looking at the photo of the Midway, you know? It's kind of interesting. Like her husband dies and she's like busy, you know, with GIFs and looking at photos of the Midway. I think they're trying to say that, oh, maybe those GIFs were accessed the day before Eric died when the Midway photo was sent. But there needs to be more. I don't know. I'm sure they'll have an expert to explain that.
There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Yes.
And that one was accessed at 10:42 a.m. the morning of the 4th?
Yes.
And the one with the champagne is also that exact same time?
Yes.
And the one with the farmer is that exact same time?
Yes.
And we know for sure
Well, that doesn't look good for your client. She's popping champagne. The Midway mansion that she thought she was going to make millions on. Remember, she purchased it for what? 2.9 million, but then she borrowed like 3.4 million, I think. She was hoping to sell it for like 14 million. This one, I don't know what the fuck. This is like a farmer with his like, is he like, it looks like he's dancing or something.
that the one on the bottom left was sent the day before.
Yeah, but she could have accessed it again on the day of.
Because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect, thank you. Okay, we can take that down now. All right, I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Kocher-Demos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Foundation.
Foundation, yeah.
Sustained. Lay low foundation.
Are you aware that there was a search conducted on her house on April 13th?
On Ms. Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say that all of those searches are believed to have occurred after April 13th of 2022?
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
Oh gosh, so we're going with, well, maybe it wasn't Kouri that did those searches. You know, it was her device and stuff like that, but it could have been someone else.
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up, do we have the, do you have that orange notebook exhibit? I
Well, we
can't
blame
remember
the
number of it.
kids.
Court's indulgence for just a minute, I have the number. I've got it. I'll tell you. I don't want to accidentally
Hey lady, how are
call the
you?
orange. Keep going. At the bottom, or why it was written.
I do not.
And you don't know when it was written.
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there is an entry that says on March the 22nd, can you highlight that please, Katie? Kouri starts counseling. Do you see that? You need to say yes.
Yes,
Okay.
sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
Why does it matter?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if a mental health counselor was part of those, but that's possible.
And I imagine as I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator. You've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
Your Honor, maybe approach him.
I'll move on. I'm done with that.
Oh, so she was trying to say that she was journaling because of trauma, and it wasn't because she was trying to craft this narrative that would be helpful if they ever did search her house and be like, oh my God, look, she must have been telling the truth. Look at her diary. She even wrote it in her diary. Well, you know what they used against her in the diary? The fact that they celebrated, had drinks, lemon drop shot, Moscow Mule, and they were like, oh, well, that's probably the avenue that Kouri used to poison him.
Are we approaching or moving on?
Well, if we're moving on from the subject matter, no need to approach.
Got it.
We are moving on from the subject matter.
Very good.
All right, you also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it, yeah. I mean, it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you. The second one, 816R, I think. Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that one's got things
Would
blurred.
you help us out? Thank you. Let's see. This is 8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Judge, Katie does have this one if you wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we
One.
switch it back to her, please? I'm so sorry.
No problem.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay, do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it or right under it? Do you see another in loving memory right below it?
Yeah, it looks like a program pamphlet from a funeral.
Okay. All right. Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins' house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing texts between Eric and Kouri, Katie, if you could pull up Exhibit 2 dash, I believe it's 9. Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed.
Yeah, that was part of our investigation.
Right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had had. I guess it depends on the timing that you're asking about.
Okay. I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you look at in trying.
Can we see the messages, please?
Just refresh your recollection. Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it.
Okay.
Does that refresh your recollection? Do you remember reviewing this series of texts between Kouri and Eric relating to the trust?
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor.
Your Honor, may I approach the state?
No, that's not true.
Okay, let's jump around.
Saying anything anyone told you.
Oh, Kouri's mom is here. Hey, Kouri's mom. What's going on? She wearing blue. Daughter's wearing yellow. Got some spring colors in here.
When you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's based on hearsay.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it. There may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon his prior answer. You can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you.
Oh, we're not going to see the
All right.
text.
Now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury.
I mean, now I want to see the text message because was Kouri saying it jokingly that Eric was like possibly hiding assets from her? I don't know, man. It seems like based on her reaction, it seems like she was very surprised that he did that he was one step ahead of her. I don't know. I want to see the text messages because we have seen the defense counsel misrepresent text messages before.
That in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor. Foundation. That's not what happened.
I think your recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay.
Oh, let me open my door really quick. It's actually oh, I guess it's really hot outside probably. Hey, don't cone him. Don't stab him with your cone. Cheryl took the bone. Kouri's color definitely orange, preferably orange jumpsuit. Orange is the new black.
Did you become aware that at least in some context there was a discussion on about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Ms. Staking, from my memory, testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor, is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay. All right, I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate
Carmen's
of Carmen
friend.
Laubers. She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second.
All right, Susan Kohler. Let's see. Is she making faces at her attorney, or she's making faces at the judge? All right, so Susan Kohler was the one who connected Carmen to Robert Crozier, the former drug dealer. He was allergic to Kouri.
The relevance objection is sustained. Ms. Nestor, please proceed.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills, in the mudroom walkway cabinet in the house. They were tested.
Contained.
Sir, please proceed.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills, in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
Thank you. You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Cocherdimos.
And you also reviewed the phone calls. Well, strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up.
I mean, even if they were to track Eric's movements while in Mexico, are they going to be like, see, look, Eric went over here. There's a known drug dealer in Mexico that lives right there. How would that help them in any way? What is that question?
All right, we're almost done. So just to
almost
recap a couple of days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah.
And
Or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
They have investigator, right? She testified here.
Yeah.
Okay.
They're a civilian investigator.
Fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in
He's
all
like
of that,
44, I think, isn't he?
we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach? Did you find anything else that had fentanyl in it?
Oh, I mean, technically, fentanyl was the murder weapon.
No,
Okay. You can't say how the fentanyl was administered, right?
orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay.
Oh no, Miss Nestor, are you okay? So usually defense attorneys in cross-examination, especially with a very important witness like this, they want to end with bang, 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 bang. And then the answers from the witness would be, no, we don't. No, we don't. No, 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 no. But this witness is pushing back so much. She's like, there's no murder weapon, is there? He's like, well, a boatload of fentanyl. She's like, well, you can't say how it was administered. Well, actually, we know that it was administered orally. Okay, but you don't know the time. Well, we know the time range. You don't know the dosage. Well, listen, fentanyl doesn't come in dosage. She's like, fuck, give me a second here. Come on, I got something. I got something here. Oh my gosh. Her momentum was definitely killed in many, 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 many ways. Can we listen back again? Go Driscoll.
There was a boatload of fentanyl.
That were over, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach? Did you find anything else that had fentanyl in it?
No,
Okay. You can't say how the fentanyl was administered, right?
orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay. You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company, have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach for 1 second?
Sorry. I was wondering why Miss Nestor was doing all the heavy lifting. For the past few days, it's been mostly Miss Nestor. Where's everyone else? Is Mr. Ramos doing most of the questioning in the case in the defense's case in chief or something? I'm so confused. Oh man, poor Miss Nestor. Give her a break.
Are overruled. If you would restate that question, if you can, exactly.
I will. And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
What? What?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on?
You know, when they were going over the form, did they make it clear that that's the PO box, and then also that the phone number was incorrect or something, because that was in pretrial. They said the phone number was not correct, so Eric had no way of knowing or getting any information about this life insurance policy.
Documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission, purporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection. Well, not objection. Maybe approach.
Sure.
Thank you.
I knew she was going to mention that. Well, Kouri was given power of attorney, so I'm sure it's fine that she signed under as Eric. That's different, though. You have to make it clear that it's a power of attorney signature, right? You can't just go willy-nilly signing for someone forging their signature. They can sign for you, but she has to sign under her signature. Also, someone's name is Jarvis Butts. I don't know. Law and crime notification just popped up. What a name.
And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
Not Eric.
probably not Eric.
But he could not say that it was signed by Kouri, correct?
Correct.
But he gave a really good explanation why. Because if you were to compare that fake signature of Eric's with Kouri's, it doesn't matter, because when the person is signing, they're dropping all their characteristics that they normally use for signatures. And I think like the exact framing he said, I forgot what it was, but essentially if you're copying someone else's signature, you're not going to incorporate parts of your signature in it. You're going to try to copy that signature style, right? So there's no point in comparing and see like, oh, you know, Kouri did sign this.
Okay. Detective, thank you, Your Honor. We tender the witness.
Mr. Bloodworth, within the scope of cross, please.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
And in early...
So like maybe here it's different. So he's lead investigator for the sheriff's office, and then the county has their own investigators that they hire. I don't know. I still feel like the answer would be like, yes, I should know everything. Know it all.
2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Cochodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not till March and April.
Well, let me ask you this.
January, 0.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when me charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Cochadimos and Ms. Carrington?
Yes.
And is Mr. Cochadimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about, can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know.
And
She
did-
had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And
We
did it-
didn't even get into that until well after.
And did it predate any of Mr. Cochadimos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office, was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Be my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building
To this building?
to
or
meet
this
with prosecutors or talk with her attorney. They're here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No. It has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
Wait, what? We made such a huge deal. Oh, that's right. It's not even Eric's. It is the kids. That's what I remember from pretrial stuff. Oh my gosh, we're making such a big deal about Eric having EpiPen. But Eric had to use one of his child's EpiPen because he was having a crazy allergic reaction, or so he saw it. He was getting hives or something. Oh boy. All right. The fans, y'all are just like, y'all are driving me nuts a little bit.
The GIF image from his cell phone. Anyone.
Oh, and going back to Ronnie Darden's cell phone, remember, if Ronnie had some information that was exculpatory to Kouri, I'm sure he would have provided it. But maybe he did it because that didn't exist.
Upon probable cause.
No, it has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey that says, idiots, idiots everywhere. Is that from the TV show House of Cards?
From my understanding, yes.
Thank you.
Counsel, why did you bring it up? Were you just trying to remind the jury what it was? Okay, then. He knew what he was doing with that. I hope we have a long lunch break today. I want to work out.
This witness,
Yes, Your Honor.
Mr. Bloodworth.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
Thank you.
Really? Very nice.
Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it. So the state could. I think we marked it as 865. We'll admit that now.
Okay. Can I see it for a moment?
Your Honor, I think if we just admit it now, during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. States Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties.
So that whole thing this morning that we spent about an hour and a half or 2 hours on, the defense decided not to take that route. But let's see if they introduce it in a different way through a different witness. I see Mr. Ramos is up right now, so maybe Mr. Ramos is arguing to have this case dismissed because the state hasn't showed enough evidence to show that Kouri, could have possibly be found guilty by a jury.
Mr. Bloodworth,
Your Honor, state's in an interesting posture.
do you need a moment on the record outside the presence of the jury?
We do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day. Are we going to be able to, it seems likely to me, you tell me, that we'll be taking a recess now but not coming back for about 90 minutes. Does that sound about right?
Huh?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay. Well, in either way, I'll bet you steak dinner is going to be about 90 minutes, but we're going to rise for the jury, and I'll send out word through the bailiff.
All right, jury.
I think the jury gets a 90-minute break, but not us.
Witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses in the state's case of chief so far, I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case they'll open the door to it. If they do,
Yeah.
the state would be able to respond
And
by,
double.
among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman,
Bond Savage.
Mr. Bonsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay. With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
All right, and I think we've always seen this in every trial. I don't think there's ever been a time where the defense did not. I forgot what it's called. It was like a motion to something. But I feel like every time in the trial after the state rests, the defense, they try to get this case just thrown out without even having to present their case. And then if the judge says yes, it's like, okay, well, that's it. The state has not put on enough evidence and we're good. Kouri, you're good. But normally, it gets denied. I haven't seen it get granted yet. So let's listen to Mr. Ramos and his thoughts on the evidence put forth and how he thinks it's not enough to convince a jury in a reasonable doubt that Kouri is guilty of the charges.
Your Honor, under both Rule 17-0 as well as 77-1713, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict.
Oh yeah, directed verdict.
At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, The court may issue an order dismissing any information or indictment or an account thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here.
Okay.
In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage, count 4, insurance fraud is that Ms. Richins, or rather, True Stage left the voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured Oxy from Ms. Lauber. That
Oxy?
while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl. That Mr. Crozier did not provide fentanyl. Rather, he provided prescription-grade oxys.
Nope.
From that moment, from the supplier, Mr. Crozier...
Sorry, we got to listen to Crozier's interview, and he seemed lucid, and it seems like he did change his story. Why did he end up changing his story? Who fucking knows?
To Ms. Lauber, the evidence is that what was provided was Oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl?
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level, non-prescription pills were going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer your Honor's question.
Okay.
Count 3, as I understand it, is that Ms. Richins, again according to the criminal information, had indicated a phone number with an incorrect digit, the signature on the application that purported to be Mr. Richins as a forgery. We talked about count 5. And then in the context, I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree, or the
P.O. box circumstantial evidence that Eric didn't know about it.
Not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer your Honor's question. Also, an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000.
Okay.
But the actual value of that, I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to
Huh?
allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, but I will
I think she intended to take Eric's life all the way back in December, and then she's like, okay, well, since I'm going to take his life, you know, I might as well just maximize it and do the most out of it.
attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. Coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, one. Even if it was oxy, and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else. I believe that
Of what, the egg sandwich? Oh man, I wonder what the diner owner is going to think about that. Honestly, I don't know why they're stipulating and saying that, oh yeah, he consumed the egg sandwich. They could just say that he never consumed it. How do you know he ate the sandwich? Maybe he got sick and he never even finished it. I don't know, because I think the other point that the defense attorney could also be making is like, oh, well, maybe he ate the egg sandwich and got food poisoning from that.
the evidence is scant. Your Honor has a question.
No, I'm following.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count 1. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the Code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Oh. Oh. Okay, they're not going to reach for the stars and try to get a directed verdict on all 5 charges? Because he mentioned forgery. He said that there was no proof that Eric allowed her to forge the signature. They addressed the true stage insurance fraud. They mentioned that what did they mention? P.O. Box, don't know if Eric had access to it. Maybe he did. I think the judge was like, well, the other thing was that maybe Eric didn't know about the P.O. Box. That's what the judge said. And that he was fighting and saying that, like, oh, you know, Kouri got oxys. Lauber might have said it was fentanyl, but remember, Crozier said it was oxys. But then we got to hear from Crozier's interview, and it seems like his story changed. He talked about the lifetime insurance, the term life insurance, that there's no cash value. I don't know. And then he started getting to like the egg sandwich. Are we not going to talk about the aggravated murder?
Any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000. Well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Lauber for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when, she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence in the light most favorable to the state that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly,
Yeah, I'm really surprised they didn't touch the aggravated murder.
Bloodworth wants to respond to this. I did neglect in my argument initially as to count 2 the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor, heard that, so I would just add that for the record.
Understood.
Thank you.
Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
All right.
I thought they were taking a lunch break. Are they not taking a lunch break? Okay. Did they ever come back? Okay. They're like, they said they're gonna take, oh wait, they came back. Okay. They came back briefly.
3-1 and the defendant are present. The issue before the court is defendant's motion for a directed verdict, seeking dismissal of counts 1 through 5 in the operative information.
Oh, okay. It was 1 through 5. I don't know. I just felt like he barely touched the aggravated murder stuff. He talked about the egg sandwich and he talked about the true life and the insurance stuff. Mini break. All right. Judge is going to make a decision. I thought he would go into more details.
It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied. Ms. Nestor, you asked for time to speak with...
It looks like she's seething or something.
your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m., just confirming that to the extent the defendant will be putting on evidence and calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess.
I know, right? She does look like she's raging inside. Oh, man. Alrighty, well, lunchtime. Lunchtime sounds amazing. Alrighty, so we spent a large portion of the morning discussing a question or a line of questions that the defense attorney wanted to ask O'Driscoll. And after the back and forth between the judge and the state, and eventually the judge was like, okay, well, if you want to go down this route, you're basically opening the door for the state to get in their side of the story for this. And I don't know if you want to do that because it might not be worth it. And so it seems like the defense was like, never mind, you know what? We're not going to go with this line of questioning with this witness. So maybe they will pursue it when they present their case. We'll have to see. But the 4 questions was to investigate the accidental overdose. Did you look into the prior allegation that Eric had prior history seeking fentanyl? Because, that would be relevant. And then the other one was, in the past few months, were you aware of an individual trying to contact Summit County about the incident about Eric asking for fentanyl? And then something about, did you cooperate with this? So they are trying to bring in information from a witness. It's already been excluded. The judge has already excluded this guy's testimony. And we'll see if the defense decides to pursue it in a different way. But if the defense does pursue this, the judge came back after his break, was like, hey, if you want to pursue this defense, then the defense can bring in what Hayden said to his sister. We don't know what. And then additionally, a phone call with Nick Von Savage with an inmate. So we don't know the contents of these because they were sealed and they're private when this initially appeared on the court docket about like a few months ago or a few weeks ago. So we weren't able to know what was going on there. But we continued with O'Driscoll's cross-examination. And honestly, were there any fireworks? Not really. Not quite. They mentioned the gifts and how I think she's trying to show that the gifts were not really accessed that morning. They could have been accessed the day before because there's a photo that Eric sent of the Midway Mansion that was sent the day before. My explanation for that was the Midway Mansion photo could have just been accessed both times. The Orange Notebook counsel brought up how, do anything about trauma journaling. So maybe that's why Kouri decided to timeline everything. There was discussions about if Kouri knew about the assets were being shielded from her. But again, I don't really trust defense's characterization anymore. I feel like they mischaracterized a lot of stuff. So I kind of want to see the text message. They brought up, I don't know, Eric Mexico trip. Did you track Eric's movement while he's in Mexico? The ending though, when defense counselor was trying to kind of like go out with the boom with all the firework questions. Honestly, I think it just failed horribly because the witness was pushing back. So she was like, you don't have a murder weapon. He was like, well, there's a boatload of fentanyl that came out with his body. She said, you can't say how it was administered. He's like, well, orally. She's like, you don't know what time he died. Witness was like, I know the time range. She's like, you don't know the dosage. He was like, illicit doesn't come in dosages. And gave her a bit of a look. So, yeah, I think State came back to the direct and ended with the gifts. Oh, what's that gif with Kevin Spacey? It's from House of Cards, right? Yeah, the one that says idiots, all of them, or something like that. Just to remind the jury of the gif. And then at the end, the defense argued for a directed verdict, saying that there was insufficient evidence. I didn't know he argued for all 5 counts. He was mainly focusing on going backwards. And I felt like he didn't really touch too much on the aggravated murder stuff. I mean, he did talk about the egg sandwich. And I mean, I guess he did talk about how like oxy was obtained and not fentanyl. So I guess maybe that covered the aggravated murder. It was denied. So the state argued, saying that at the time that she forged the signature, she had already told Josh that she wanted to have a fresh life with him. She told Becky that Eric would be better off dead, and that it would be better if Josh. She told Josh that it would be better if Eric just went away. So when she did the insurance fraud, allegedly, a jury could find that she did intend to kill him. So again, that was denied, and they're on their lunch break. So because we had so many delays today, I will come back 30 minutes after the court returns because I don't trust them no more. We'll see if Kouri's going to decide to testify because their motion was for a directed verdict was denied. The defense, I mean, they probably had an inkling for that, so they already, had a strategy that they were going to move with. But we'll see if Kouri ends up testifying. But I think today they already have witnesses lined up, and we'll see how that goes. All right. Laugh, love, kill. Hiya, Sarah. How are you? But what a day today. What a day. Oh, gosh. This week has been pretty rough, I would say. But I do find it entertaining to see the back and forth between the defense, the judge, defense judge, defense judge. And then once in a while, Mr. Bloodworth, sleeping on the sidelines, he'll chime in. Not that I'm saying that he's sleeping, he's not paying attention, but I think Bloodworth is just like, dude, I'm just chilling. Okay, I came to court. I'm just chilling. Alrighty, so court is on lunch break. Corgi, what did I don't relate? Corgi will return a bit. Then court. See y'all at 1. I'm gonna give him 30 minutes. I don't trust him. Mountain Standard Time. So I will see you guys in about an hour and 20 minutes. I think that should be good. I'm going to monitor court to see if, I don't know. I see the judge's head popping up and down, though. I see the judge. Alrighty, guys. Well, anyways, we have a video of the Orange Notebook reading, the Walk the Dog reading, and some jailhouse calls between Kouri and Kouri's mom and Kouri's brother. So that was the most recent uploaded video from yesterday. Feel free, to check it out. The sneeze is gone. Feel free to check it out. Other than that, we do recaps of the trial. So hopefully this week will be easy to recap, I think, because there's a lot of stuff that didn't really happen. I'm not going to recap the part where they're arguing what's coming in and out from, was it Monday and Tuesday? But I will recap what happened today because today was really interesting. Yeah. Alrighty, guys. If you guys haven't seen the recaps for week 1, week 2, feel free to check it out. And we also did a recap of the private investigator's testimony. Lots of fireworks with that one. So feel free to check it out during the lunch break. I will see you guys in an hour and 20 minutes. I'm going to be coming back a little bit later than court because they delay so much and there's just no point in me being live with them. They drive me nuts. Oh, wait, the judge is here. Should I pause it at the judge's head? Yeah, he's so happy. Like laughing. Alrighty. I'll see you guys. Hey guys, I know I said I was gonna be back at 1:30 and I'm 20 minutes early, but I decided to pop into the live stream to see, if they were coming back on time. And I was like, oh, it looks like the answer is yes. But then we just got a huge bombshell. So I'm coming back early right now, and I'm sorry. I just put a notification out on Discord. But if you guys missed this by 20 minutes, rewind back. I'm sorry, I apologize. But what the heck is happening here? We'll watch it together. Give me a second. Let me go get Remy. I left him downstairs. That's my food. Don't steal my food. Okay. All right. All right, guys, we're back. Oh my goodness. I was like in the middle of eating my sweet potato. Wow. I'm not going to spoil it. We'll watch it together. I am very disappointed. Give me a second, please. All right. Let's go back over here. And this is so hilarious. They had time to talk about this during the lunch break. And don't spoil it, anyone. Don't spoil it. Some of y'all may already know. Don't spoil it. Hello, everyone. We are back from the lunch break, and we have a very big surprise.
231-500-139. State's Counsel and Defense Counsel are present. Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
I'm going to go back up really quick because I cut off Miss Lewis. How dare me? That was so rude of me.
0139. State's Counsel and Defense Counsel are present. Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
Okay, so they have a couple of options. Who's going to go first? What are we doing? She poisoned the jury. She pled guilty. They're chatting right now. Mr. Ramos is like not into this. I don't understand. Did they not talk about this during the lunch break? Miss Lewis says we already did that.
Your Honor, actually at this time, the defense intends to rest.
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
I don't know why they were whispering so much. They're resting. Yeah. I'm so confused. How did you go from, hey, we have quite a few things, quite a few people we can call, to actually give us a moment? No, actually, let's rest. Like, did you guys not organize and talk about this during the lunch break? Hello? What the fuck? We're supposed to have 2.5 more weeks of trial. I mean, better for me. I hate waking up early. This early. 6 a.m. Fucking sucks, okay?
Just want to make sure. you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
Sir, let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin.
Eric Zed is smiling. He's smiling. See that? He's smiling.
Tomorrow, the court recess, and that we begin. The parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that. I thought.
You want the jury to have the weekend to themselves? I guess. I mean, we're assuming the jury follows instructions, but they have half of today, all of Friday, Saturday, Sunday.
We were thinking it might make sense to get the jury instruction conference out of the way, and then.
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other.
No, Mr. Bloodworth is like, I want my Fridays off. I want my Friday. Mr. Bloodworth's like, well, I propose we dismiss for the day. We have Friday off. We have like a 3.5 weekend, and we come back on Monday and we do everything. I love Mr. Bloodworth's style. He's like, I want my 3-day weekend.
About any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah. Yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
Yes, sir.
Okay. Okay. All right. Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
What the fuck, dude? We'll have the jury come in. They will both rest, and I'm gonna go back to what the fuck just happened with the defense table, because they made it seem like they're gonna call witnesses. What happened? Maybe the defense was tired of being grilled by the public. I mean, there are people that are grilling you, you guys, yes, but there are some supporters out there, okay? I admire your work. I might be poking jabs at some of the shit you guys are doing and the time wasting. I admire your work. All of you. And today was, it felt like a major waste of fucking time, because we were going back and forth about something. She decided not to include it in cross-examination. And then I was like, okay, well, maybe she will include it in her case in chief. And then they were like, you know what? We're not going to call any witnesses. Y'all could have just let people go after the lunch break or before the lunch break. But gosh.
All right, jury. Please have a seat as you come in.
All right, jury's coming in. Oh, let me slow down. I wish I knew how to parse out all the information that I gathered in pretrial versus in trial. In trial, I think the state did a good job. I just don't know if, because there are some gaps and holes. I just don't know if I pre-filled those gaps and holes with my knowledge and pretrial stuff, or if those gaps and holes were, filled in throughout the trial. I don't know. This one it's hard for me to separate. Because we've been following this case for 4 years?
Have a
The
seat,
court
thank
TV
you.
poll? Oh, I didn't see it.
Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning. I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take affirmative effort and diligence. I need you to use that same affirmative effort and diligence to make sure you avoid watching.
I'm so disappointed. I thought the defense had experts, like digital forensic experts, family members. I thought they were going to recall Carmen.
Listening or reading anything about this case from any source whatsoever, and please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning. Please travel safe. Enjoy your weekend. I'll see you at 8:30 a.m. on Monday. Please rise to the jury.
Maybe a court didn't agree with any strategy. I mean, at the end of the day, she doesn't have 100% full say, though. They can get her input, but Karungal, thank you so much for the 10, by the way. Appreciate it. I mean, honestly, I didn't think Kouri was going to testify. I wanted her to, but I didn't get a feeling she was going to testify. She would have gotten destroyed in cross. She has a tough time with even trying to present as a grieving widow, someone that has empathy.
All right, folks, have a seat. May I propose the following?
I will say this, though. At least I admire her for not trying to, fake tears, ekes him out during 911 calls or certain testimonies.
Counsel have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30?
Do you want to do it a little later just so I have time to look at whatever happens?
You suggest?
Late as possible.
You want to do
Miss Nestor was like, please, let me sleep in.
it 1?
Yes.
Sure.
Mr. Bloodworth?
Sure, sir.
All right. So you're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Richins, 1 p.m. tomorrow. The court is in recess. Thank you. All rise.
Okay. I guess I'll listen to the jury instructions. I don't mind. Yeah, I guess we listen to jury instructions. Okay, so let's go back and see what happened. Now we have some indicators here. I don't know. I was really looking forward to the experts that the defense was going to call, because I had a feeling they were going to call their own digital forensic expert. Didn't they have someone that was supposed to testify about? No, the pathway to violence was supposed to be from the state, right? In rebuttal to an expert that. Oh, yeah, that's crazy. They had so many people they're going to call. I mean, I guess it could mean that the defense feels like, one, that they're good. They're good. They don't need to present their side. They're good. They don't feel like the state did a good job. Or it could be that if they do present their side and call their own witnesses, it'll end up doing more harm. It'll end up being more detrimental. Maybe if their people gets crossed by the state, I don't know. But what I think is really interesting is that we came back from the lunch break and it wasn't like the defense said that they were going to rest their case with confidence. It was like, yeah, we got a couple of routes that we can take, Can we actually talk first? Okay, they talk and they're like, you know what? We rest our case. And it's like, wait, hold on a second. Wait, what? Did you guys not discuss this during the lunch break? I don't know. I'd be very interested to hear. Can they tell us about the why of that portion?
231.
I mean, honestly, I do think, like I said, I'm trying so hard to parse out the information that I know from all the pretrial stuff. I think if I'm only looking at the trial, I don't feel confident about the attempted poisoning. I don't feel confident about that one. The fraud, the forgery, the signatures. I mean, for sure, I do believe it's not Eric's signature, okay? But I think it's possible that members of the jury could just be like, oh, well, I've signed some shit for my husband before. He let me. And I think it's possible that they would think that, I don't know. I'm a little iffy about the attempted aggravated murder. The forgery, yes, I would say yes, forgery. She forged it. But then I don't think the state, I have to go back. I really don't think so. I don't think the state made it clear on that form that one, that P.O. box is Kouri's and only Kouri has access to it, even though it does say Kouri's name, right? But maybe Eric, because my P.O. box is my husband, is under my husband's name. I have access to it. I don't think they made it clear about that. And I don't think they made it clear that in the phone number, unless it's wrong, on the insurance form, the phone number in the state's pretrial documents, it said that the last number in the phone number was incorrect. So it seems like Kouri filled out this form and Kouri wanted to make sure Eric didn't know about this because she had her P.O. box and she put in a wrong phone number and did not include Eric's email address. So I don't know. I'm a little iffy about that one because I wasn't sure if the state was clear about that when they went over it. I guess I have to go back. But I think getting the fentanyl, Eric eating all that fentanyl, I think it's pretty good. I think it's pretty solid. All right, so let's go back. Sorry, I'm yapping.
15001.
Oh, the Google searches are really bad too. Yeah.
139. State's counsel and defense counsel are present. Ms. Richins.
And also, I think this confuses the jury. You know how they showed Kouri's diary and they showed Kouri's notes about the timeline of what happened? So how it was presented to us in pretrial and to the judge was that Kouri wrote out the timeline, right? And from that, we can use it against her because of the Moscow Mule and the lemon drop shot. That's how they got that idea from. But I don't know if they really highlighted that through testimony. They just let the jury read it. And then additionally, when there was a second timeline that was found in Kouri's drawer, I don't know if the jury was just like, oh, wait, so we found two timelines and it seems like Kouri's story is consistent. Okay. She went to bed. Okay. I don't know. I don't know if they looked at those timelines and were like, oh, this is weird. Because if I was a jury and I only read the timeline, I would just be really confused without context given. I felt like there wasn't enough context given, but maybe I missed something.
Is present.
Also, the book evidence, I thought the book evidence was a little weird too, because if anything, I think it could show that she was grieving. She did feel sad for her kids, and that's why she wrote the book for her kids. There were some clear points that were being made in pretrial that I was like, oh, that looks really bad. She wrote the book. She's trying to make money. She's the one who killed the kid's father. But like in the trial, I'm like, I just don't know if it's really clear. It's like, okay, the state showed that she wrote a book. All right. Yeah, I don't know. Anyways.
Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
They said ready to go. I'm so confused. Now they're looking at each other.
Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
Right? What do you guys gather from that? They have a couple of options. They're going to decide on who to call. Well, I'm so confused about this portion. What is happening here? What was the other option?
We don't want to. Your Honor, actually, at this time, the defense intends to rest.
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
It is just so weird to me how that went down. It was like, okay. I'm assuming they already knew they were going to rest before they came in, but because of what they said, it doesn't seem that way. I'm so fucking confused.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay.
All right, so she's going to waive.
You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here?
All right, and that's it. And this is where Bloodworth is like, hey, Judge, can I get 3.5 days off this week? Thank you. Thank you. Let us come back on Monday. And then they're like, no, we got to do jury instructions. Like, damn it. Bloodworth trying to get Friday off. All righty. Well, that's it. That's it. This trial was slated for 5 weeks, and it ended up only being 2.5 weeks. Or 2 weeks, actually. Day 14, but I would say 2.5 weeks. Or 2.5, yeah, 2.5 weeks. So guys, that's it. All right. I mean, honestly, I like short trials. Short trials are great. Trials are really long and lengthy, but I will have to say I was really disappointed because I was really looking forward to hearing the witnesses that the defense was going to call. You know, they're experts. They're going to call family members. They're going to call back Harmon again. And there was a route that the defense entertained of taking where it would have brought in a bunch of interesting testimony that was sealed in the pretrial stuff that we didn't get access to. Especially referring to, I forgot what that guy's name, some guy who purported to say that Eric reached out to him for fentanyl, but his testimony was excluded. The state said that his, I guess like his story was, what did he say? It was like properly dismantled. I forgot what he used. It was like a really interesting term. People in Utah and people in the law field use very interesting phrases. But I thought that would have been really interesting. It's like, oh, then we get to know about, Mr. Norris. We get to know about what Hayden said to his sister. And then the Nick Von Savage call with the inmate. I was like, oh, we're getting to some very interesting territory. But then the defense was like, nope, just kidding. We're not gonna go there. Yeah, it got really interesting. And now it's just kind of like, okay, well, this is what I kind of been feeling towards the defense. It's like we have a lot of hype, and then the payoff is just not there. But like I mentioned before, the defense could possibly feel like they don't need to put on a case because they didn't think the state did a great job. it could be that the state feels or defense feels like if they were to call their witnesses, it might be a waste of time, maybe too lengthy, and maybe the witnesses won't do well in cross-examination. I don't know. Or maybe the rebuttal might, if the state calls their rebuttal witnesses, it might be more damaging. I don't know. This is all kind of interesting. So, all right, guys. Yeah, I mean, we have a lot of really bad incriminating evidence against Kouri. Like I mentioned before, Kouri has basically checklists, everything to not do in a murder case, She had an affair. She planned her life with the affair, right? She had these incriminating messages to friends. She told friends incriminating things. They testified against her that he'd be better off dead. She even said it to her affair guy that if only he were gone, right? Then there's like the stealing money. And then there's the life insurance stuff. There was the writing things in your entry. There's the attempted witness tampering, alleged attempted witness tampering. There was calls that were recorded, notes that were diaries that were written down. Like Kouri she just hit almost everything, you would, that happens in other cases. Usually you'll get maybe 3 out of 10, 4 out of 10, but I feel like Kouri just hit everything. Oh, and the Google searches, right? Really tough. But like I said before, it's hard for me to kind of separate the information that I know in pretrial stuff. During this trial, though, there were parts where I didn't feel like they really hammered information in. So like the life insurance policy form, I have to go back and watch it. Maybe I missed it or something. The attempted poisoning with egg sandwich, I think that one might be really hard to try to convince a jury that she's guilty. But yeah, I think the aggravated murder, the Google searches look really bad for her. The steps that she took before she called 911, after she called 911, her demeanor on the 911 call, her demeanor in the body cam footage, how she planned this life with another man, what she said to her friends, what she said to the paramour. And honestly, there was no one in Kouri's support. Kouri had her mom, but I don't know if the brothers are even supporting her anymore. They're not here. So very interesting. All right. Yeah, there was a lot of self-snitching action. I guess Kouri didn't watch Bruce Rivers. All right, guys. Well, that's pretty much it for today. We are going to do a recap of this week. And although it felt like not a lot happened, there were some very interesting exchanges this week. I think there's probably 2 of the most spiciest exchanges between the defense and the judge that we'll include. I think one was from Monday or Tuesday, and then one was from today. So we will be working on the recap for this week, and I'll have it all ready for you guys for the weekend. They're coming back tomorrow for jury instructions, and then we'll do closing arguments on Monday morning. All right, y'all? Well, that's it for today. Thanks for hanging out. I hope you guys have a good one. Have a good weekend. I think I'll pop in for jury instructions tomorrow, but that one will be a... yeah, because I think I do want to go over the jury instructions. So we'll see if I stream it or not, but I think so. Alrighty, guys. I hope you guys have a good one. Take care. And oh yeah, I thought they were gonna try to call Bryce and then bring up those text messages and emails, with all the sexting stuff. That we're gonna do that. All right, disappointment. Guys, have a wonderful week. Take care. We'll do the recap. And if you guys aren't caught up with this trial, watch our previous videos. Alrighty, y'all? Have a good one. Take care. And if you want to watch all the pre-trial stuff that's happened in this case, because this case has been it's been wild. It's up there. Almost as wild as Sarah Boone, I think. There is a Kouri Richins playlist. Feel free to check it out. Like the stream, and I will see you guys a different day.